Well, thank y'all very much for coming. My name is Bradley Pierce, and I am an attorney. I'm a husband, father, Christian. That's the most important thing about me. I will have some time for question and answers at the end. If you have any of those, we can talk about that. But I'm here to talk about something that should matter to every Christian, and that is the subject of abortion and what we should be doing about it. Let me ask you this. Please raise your hand if you call yourself pro-life. Please raise your hand. All right. Well, for the last 48 years, the pro-life movement has been fighting against abortion. And I'm here today to ask you to be an abolitionist. And I want to tell you about what I mean by that. You may be saying, well, am I an abolitionist? Well, let me ask you some questions. Number one, do you believe that the Supreme Court should overturn Roe versus Wade? That's question number one. Question number two, do you believe that a fetus or embryo or zygote or any child before the age of birth, do you believe that a fetus is a person? And then number three, do you actually believe that? Do you actually believe that Roe versus Wade should be overturned and that a fetus is a person? And do you act consistent with those beliefs? That's what I want to talk about. If you answer yes to all three of those things, then congratulations, at least as far as the criteria for bills that you supported or opposed, then you're an abolitionist. And I'm going to explain that in a minute. You believe that Roe versus Wade is unconstitutional or that it should be overturned, that a fetus is a person, then you act consistent with that. The problem is that the pro-life movement has been saying these things for 48 years. The pro-life movement has been saying that Roe should be overturned. The pro-life movement has been saying that a fetus is a person. But for 48 years, we've not been acting consistent with what we've been saying. So what do I mean by that? So what does 48 years of trying to end abortion by changing the Supreme Court look like? Because that's been the primary strategy of the pro-life movement. In fact, you can really talk about the strategy of the pro-life movement, that there are 7 elements to the strategy. Number one, elect Republican presidents to appoint pro-life justices to overturn Roe versus Wade. And while you're doing that, pass incremental legislation to undermine Roe, to save some babies, and to weaken the pro-abortion movement. So we're going to be walking through that, talking about what that has looked like for 48 years. So going all the way back to 1973 when Roe versus Wade was decided, this was the makeup of the court. And the red means that they were appointed by a Republican president, and the blue means they were appointed by a Democrat president. And you may be looking at that, and that may look familiar to you, that there would be 6 Republican appointees and 3 Democrat appointees, because that's exactly where we are today, 48 years later, and yet we still have not outlawed abortion. And that's the court that gave us Roe versus Wade in the first place, was a strongly Republican-appointed court. And the judges who ruled for it, there were 5 Republican-appointed justices who ruled in favor of Roe versus Wade. And against Roe, it was a 7-2 decision. There were 2 against. There was 1 Republican and 1 Democrat appointee who were against Roe versus Wade. So because there were 5 Republicans in favor of it, even if the court at the time had been completely Republican appointed, we still would have gotten Roe versus Wade, because it just takes 5 of the 9 to give us that opinion. So it's really Roe versus Wade. I know we talk about Democrats a lot, but really it's a Republican-appointed justice's opinion. That's who even wrote the opinion, was a Republican-appointed justice, Justice Blackmun. Well, let's fast forward a little bit. What happened from Roe versus Wade is that for the next 19 years, we had 4 other presidents. We had 3 Republican presidents and 1 Democrat president. The Democrat president, Jimmy Carter, did not get to appoint any justices to the court because there weren't any vacancies during his term in office, which means that for 19 years, every single justice appointed to the United States Supreme Court was appointed by a Republican president for 19 years. And in fact, of the vacancies that they were filling, every single one of them was someone who had voted in favor of Roe. So of the 7 justices that had voted in favor of Roe, by 1992, 6 of them had been replaced 100% by Republican presidents. So by 1992, the court makeup was 8 Republican justices and 1 Democrat, and the Democrat was pro-life. So in 1992, we had 8 Republican-appointed justices and 1 pro-life Democrat. You would think if we were ever going to overturn Roe, that was the time to do it. But as we all know, that's not what happened. In fact, in 1992, in the Planned Parenthood versus Casey decision, they doubled down on Roe versus Wade and reinforced Roe versus Wade. And in fact, those who voted in favor of Roe versus Wade were 100% Republicans. And the pro-life Democrat still voted against it. So of those who had been appointed since Roe, 4 out of 6 of them voted to uphold it and to double down on it. So that's 2 out of 3. And in fact, of President Reagan's appointees to the court, 2 out of his 3 ended up voting in favor of Roe versus Wade. So I like to say, even if we had President Ronald Reagan's from now into infinity at the rate of 2 out of 3 voting in favor of upholding Roe, we're never going to overturn Roe, continuing with our current strategy. Today, of the justices on the court, only 1 current justice, Justice Thomas, has ever publicly opposed upholding Roe versus Wade. And some may say, well, there haven't really been any opportunities to deal with Roe versus Wade. So we don't really know where Roberts, Alito, Gorsuch, Kavanaugh, Barrett are. Well, I hate to burst some people's bubble, but there have been opportunities, and we kind of have seen where most of those are. In 2007 and 2016, Justice Thomas twice wrote opinions opposing Roe versus Wade. He asked his fellow justices, which included Roberts and Alito, to join him in those opinions. Scalia joined the first of those. By the second one, Scalia had passed away, so he did not join him. But the other justices, Roberts and Alito, who were on the court at the time, they said, no, we're not. We don't agree with you. We're not going to join your opinion that says Roe is unconstitutional and should be overturned. We're not going to join that. They did that twice in 2007 and in 2016. So even since then, last year, there was a case that came from Louisiana. Louisiana had some abortion regulations, went up to the U.S. Supreme Court, and the Supreme Court issued an opinion just last year. And in that case, June Medical Services, Justice Thomas, again, he wrote an opinion, a dissent, that said, quote, the Constitution does not constrain the state's ability to regulate or even prohibit abortion. In other words, it's perfectly constitutional for states to ban or restrict abortion, Thomas said. And then he went on to say, because we lack jurisdiction and our abortion jurisprudence finds no basis in the Constitution, I respectfully dissent. So he essentially said Roe versus Wade is unconstitutional. It finds no basis in the Constitution. Roe versus Wade, Planned Parenthood versus Casey, all these other decisions find no basis in the Constitution. They're unconstitutional. And he asked his fellow justices to join him in his opinion and put their names on it too. He asked Roberts, he asked Alito, he asked Gorsuch, he asked Kavanaugh, and all of them said, no, I'm not going to put my name on that. That's all they had to do was say, yeah, put my name on that, and their name would be on it. But they were not willing to support that. And in fact, Alito wrote an opinion that said that the district court should have applied Planned Parenthood versus Casey. In other words, Alito even kind of speaks favorably of Planned Parenthood versus Casey, which was that 1992 decision that just doubled down on Roe versus Wade. And it seems like every time I give this talk, I add another case where, hey, here was an opportunity for all these justices to come out against Roe, and all we hear is Thomas. Nobody else is willing to do that. So as far as the strategy of the pro-life lobby, it hasn't really been going very well for 48 years as far as overturning Roe. Has Roe been overturned? No, it has not. And yet we continue to go down that road and make that really our primary focus for how we choose to deal with Roe versus Wade. Since that 1992 decision, we've had presidents and senates and House and court. And a lot of people say, like, yeah, Bradley, but we haven't overturned Roe versus Wade because of the Democrats. It's their fault. Well, remember that all those justices appointed from Roe to 1992 were all Republicans. Okay? And remember the original Roe decision? That was Republicans, 6-3, were on the court at the time. Yeah, but the Democrats. Wait, but there's been 4 different congressional sessions, which are 2 years each. There's been 8 years since 1992 when we have held everything, the presidency, the House, the Senate, and the court. 8 years, a 6-year period, and then during President Bush's term, and then a 2-year period during President Trump's term. And yet, we still did not overturn Roe. We didn't even defund Planned Parenthood during those. So, and yet the Democrats, they've only held, 2 branches, the president and Congress, during 2 congressional sessions. So again, when we're talking about who's the one dominating the federal government, it's been the Republicans, by and large, since 1992. As far as who's dominating the court, it's been the Republicans for 48 years. So that's not to defend the Democrats. I'm not speaking in defense of them, but we need to understand what's really going on here. What I'm here to do is show you that this idea of our strategy being all about electing Republican presidents to appoint pro-life justices to overturn Roe versus Wade hasn't worked. It hasn't worked. And you may say, well, okay. I know it hasn't worked, but I mean, there's silver lining, right? At least we've passed some pro-life bills. At least we've passed some pro-life bills in our states. We've passed some incremental bills. We've been doing that. That's part of the strategy. What does that look like? Not very good. Doesn't look great. These are just the pro-life bills that got to the U.S. Supreme Court. And there were a whole lot more of them that have been dealt with in the circuit courts, because the Supreme Court doesn't have to hear every case. So a lot more have been dealt with in the circuit courts or local trial courts. But these are the cases that have gotten to the U.S. Supreme Court. These are the pro-life bills that have gotten there in the 70s, in the 80s, in the 90s, and then since 2000, in the 2010s, 2020s. These are the pro-life bills that we've been passing for 48 years that are going to the court, and the court is repeatedly striking them down over and over and over, by and large. You notice that the numbers seem to be dwindling as we go on, and I think it's because we keep running out of things to lose on, right? And in fact, sometimes we're even going back like, hey, you know that thing we lost on 20 years ago? Let's try that again and lose on it again. Like the Louisiana case just last year was something that we had lost on that exact same basically the same thing 4 years before, but hey, let's try it again. So yeah, we've been passing some incremental legislation, but by and large, it's been struck down, right? It's not going into effect. And that most of it that actually does anything doesn't end up going into effect, and we just keep getting struck down again and again and again by the federal courts. So yeah, but okay. But we've been undermining Roe along the way. We really haven't. I'm not going to get into detail here, but even the cases that we have won have really just solidified one thing, and that is that in this country, abortion is health care. You have to have a license to perform an abortion. You have to report the abortions, or you can require that abortions be reported and things like that. Basically, abortion is health care in this country, and that's the extent to which we're allowed to regulate it by the Supreme Court. We've lost a whole lot more cases over the years, and I'm just skimming through these, but basically we've lost the ability to do anything to, in any major way, restrict or regulate abortion. And in fact, the ultimate Supreme Court test is, does this unduly burden a woman's access to an abortion? And even our own Fifth Circuit, federal circuit that governs Texas, that includes Texas, has said you cannot enact any kind of ban on abortion under Roe versus Wade or Planned Parenthood versus Casey. So we've lost everything that really matters much. So some people, though, again, we don't want to admit we're losing, right? We don't want to admit that we're just on this hamster wheel. So it's like, well, but we saved some babies, right? We saved some babies. Well, abortion numbers are going down. Thank God they are. Or at least I should say reported abortion numbers are going down. Those that are reported are going down. We have here Texas over the last couple decades here. The numbers have by and large been going down. The blue, which is the blue line, the orange line is actually chemical abortions. You see those. They took a dip, but they're trending up. But what matters more important than just raw numbers, if we're going to compare state to state, is really the rate, right? The rate, because your population increases, you're going to have some increase. So, okay, what does the rate look like? The blue line is the abortion rate in Texas, and the orange line is the overall rate of the United States of America, of the whole country. And you'll notice that the entire country is going down, right? The abortion rate in the entire country, on average, is going down, and Texas really isn't going down much more, if at all, overall, than the overall U.S. abortion rate. And again, you may be thinking, well, that's because of all the pro-life states are passing all these pro-life bills that making abortion numbers go way down, but in all the pro-choice states, all the pro-abortion states, the Democrat states, their abortions, aren't going down, or they're going up because they're passing bills that allow abortion up until birth and things like that, like New York did. Their numbers are probably going up, but because the pro-life states are doing such a great job passing the incremental bills, they're going down so much that overall the U.S. abortion rate is going down. That's kind of something that we like to assume, but is not actually what's happening. Because here's the state of New York. The blue line is their overall abortion numbers, but apples to apples, what is their abortion rate? You'll notice there it is compared to the blue one is New York, and that's compared to the U.S. abortion rate, which is the orange line. And you'll notice that it looks pretty familiar. Looks a lot like Texas. That New York's abortion rate is also going down. Like, well, but New York, man, it's a big state. There's a lot of rural areas, more conservative areas. Well, let's look at New York City. This is their numbers, but again, apples to apples. Here's their rate. Here's the abortion rate in New York City as compared over a shorter time period from 2011 to 2017. And here's what their rate is doing. It's going down even faster than the U.S. average rate. In fact, it's even going down faster than Texas rate. Here's Texas. I put a little black line just so you can kind of compare. Here's Texas' overall numbers. Here's New York's overall numbers, dipping below the black. And here's New York City's dipping well below the black. So, and I could show you the same thing in Vermont and Massachusetts and Oregon and these states that are extremely pro-abortion and pro-death. Their reported abortion numbers are also going down. So when someone says it's pro-life bills that are making the abortion numbers go down, how does that explain why abortion numbers are going down nationwide? How does that explain why abortion numbers are going down in pro-abortion states that are going the opposite direction, that are passing bills that would liberalize the abortion laws and say you can abort up until birth in New York? And they're going down even faster than in Texas. So if the pro-life bills are saving any lives, it's very, very few, because they're going down even in states that are not passing any pro-life bills whatsoever. Okay, but the comeback may be working our way down the strategy. Okay, yeah, 1 through 6 aren't really going the way that we want it to, but 7, we've been weakening the pro-abortion movement, right? I think you know where I'm going. No surprise at this point. No, we have not. We have not been weakening the pro-abortion movement. This is Planned Parenthood, which I think everybody generally, recognizes as the giant in the abortion movement. This is over the last couple of decades what their government funding has looked like. This is what their revenue has looked like. And in fact, you may say, well, if we're passing all these regulations, shouldn't it be hurting their business? Well, just kind of step aside for a moment. In economics, just think about, there's certain kind of businesses that don't like regulations, but there are other businesses that love regulations. There are other businesses that love regulations. What kind of businesses like regulations? The big businesses, right? Because they've got the money to comply with them. They've got the lawyers to comply with them. They've got the lobbyists to go and get those regulations written in a way that they can comply with them. Well, okay, that explains why they don't mind them, but why do they like them? Why do big businesses actually like regulations? Why are they actually even the ones writing most regulations? Oh, because there's another kind of business that doesn't like regulations. That's the small businesses, right? They don't like regulations because they can't afford to comply with them. It puts them out of business. which then helps the big businesses. Because where does all that business go? It goes to the big businesses. Well, in the abortion business, and I feel horrible saying that, it works the same way. In fact, Justice Alito on the United States Supreme Court actually pointed this out. In 2016, he said, Planned Parenthood is obviously able to comply with the challenged HB 2 requirements. HB 2 was a bill that we passed here in Texas that went up to the U.S. Supreme Court. And Justice Alito points out Planned Parenthood could comply with the law we passed here in Texas, which this case ended up actually striking down. But then he went on to say the president of Petitioner Whole Woman's Health, a much smaller entity, has complained that Planned Parenthood puts local independent businesses in a tough situation. Why? Because we just passed these pro-life incremental regulations, and Planned Parenthood, they comply with them. They don't have a problem with them. But it puts Whole Woman's Health, it puts all these other smaller abortion businesses out of business. And where does that demand for abortion go? Right into the arms of Planned Parenthood. This is Planned Parenthood's market share. This is their share of the abortion market in the United States. This is 48 years of us passing pro-life laws across the country to try to weaken the pro-abortion movement, to try to weaken Planned Parenthood. And what have we instead done? Our pro-life laws have regulated out the small abortion providers and sent their customers straight into the arms of Planned Parenthood, so that now over 40% of abortions are performed by Planned Parenthood. So they have over 40% of the market share now. So this strategy hasn't been going well. To put it lightly, it has not been going well for 48 years. And to put it seriously, there's been 62 million dead. Over 62 million have died. While we've been working on this strategy, 62 million have died. So really, it's been 48 years of failure when it comes to this strategy. It's been 48 years of failure. Have we overturned Roe? We haven't. Are 55,000 children still killed every year in this state? Are 150 killed every day in this state? Can any child conceived in this state still be aborted? As long as you go through the right, motions, every child who's conceived in this state is still subject to being aborted. That's not success. It's not success at all. That's why 48 years ago, when Roe versus Wade came down, our response should not have been, I guess we need to comply with it until we can overturn it, and then we're going to pursue this strategy in the meantime. No, our answer to Roe versus Wade in 1973 as a state should have been no. No. That's not constitutional. That violates the Constitution. That's not the law of the land. We should have said Roe is not the law of the land. And so it's not binding on us. It's not binding on Texas or any other state. We should have said no to it. Because what is the law of the land? The Constitution. In fact, the Constitution has a clause called the Supremacy Clause. It says this Constitution and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. So what's the supreme law of the land? Of course, under God's law, the Constitution, and then laws which shall be made in pursuance thereof. That is, laws which are made in accordance with the Constitution. Laws which agree with the Constitution. And any law or any opinion that does not agree with the Constitution is not the law of the land. And so it's not binding upon the state. So what should we have done 48 years ago in 1973? We should have followed the Constitution. Because I, as an attorney, and our state officials, as elected officials, we swear an oath. And we don't swear an oath to a court. We swear an oath to a Constitution. And if the court is issuing opinions that agree with that Constitution, then we do need to follow the court. And when in doubt, we do need to give deference to the court. But when the court issues an opinion which is anti-constitutional, which clearly violates the text and the principles of the Constitution, then we need to obey our oaths. We need our elected officials to obey their oaths. And they need to obey, and we need to obey the Constitution and not the court. That's what we need to do because it's unconstitutional. And where the court has ignored the Constitution, we must ignore the court. We're duty bound. We're oath bound. So help us God to follow the Constitution and not the court, because we're a government of laws and not of men. We don't swear an oath to a king, right? We swear an oath to a document that is the highest law of the land. It's the supreme law of the land. And anything that violates it is not law, and it's not binding on Texas. And that's how we should have treated it 48 years ago. But it's not too late. That's how we should treat it today. We should treat that law as null and void, or we should treat Roe versus Wade as null and void today. We should ignore Roe. Well, how do you ignore Roe? Well, there's two ways. So there were laws in Texas before 1973 that made abortion illegal. Well, we need to enforce those laws because they're still on the books. They've never been repealed, and they're still on the books. However, those laws have problems. I'll talk about it in a moment. But we do need to go ahead and enforce those laws now. But we also need to enact a new law, a better law, a just law, while we're enforcing the existing one, which leads me to talk about equal protection. Equal protection, because we need to follow the Constitution by ignoring Roe. But we also need, how do we need to do that? We need to provide equal protection. And I asked earlier, do you believe that a fetus is a person? Because for 48 years, the pro-life movement has said, yes, I believe a fetus is a person. But we haven't acted like it. We have not acted like it. Let me ask you this. Do you believe that the same laws that protect you and me as born people, that those same laws should protect people before they're born? Do you believe that? Do you believe that? If you just said yes in your mind, in your heart, then you've actually just disagreed with every major pro-life organization in the country. You've actually just disagreed with every major pro-life organization in Texas here, including Texas Right to Life and Texas Alliance for Life, because they do not believe and they do not advocate for the laws that protect you and me as born people to be the same laws that protect people before they are born. They do not believe and they do not advocate for equal protection. And I believe, and I hope you'll see here, that equal protection, I believe, and we believe at Abolish Abortion Texas, that is the primary reason from a legal perspective why we lost Roe versus Wade in 1973 and why we've been losing it for the last 48 years. So let me explain. In 1857 in this state, slavery was legal. It was legal, right? And it was that way all across the country, or in lots of states across the country, I should say. And there was a case that went up to the United States Supreme Court, and the Supreme Court issued an opinion that said that a black person, or even a slave or a free person of color, was not entitled to the same constitutional rights as a citizen as a free white person. In that same year in Texas, in our penal code, we actually had a different section. We had a section of our penal code that was actually titled, it was laws that applied to slaves and free persons of color. It's like the rest of the penal code applies to white people, but there was a section of our penal code that applied to slaves and even free persons of color. And you know what? If they committed a crime, certain crimes, a slave or a free person of color could be branded on their face with a hot iron in the shape of a letter C. Oh, but you couldn't do that to a white person. You couldn't do that to a white person. And our penal code actually said that a slave or free person of color is a person, but they get a different justice system. So we said they're persons, just like even under Texas law, it currently says from the moment of fertilization, the fetus is a person. But we don't act like it. They get a different justice system. And this is what it looked like before Roe versus Wade, that a man, if he were to intentionally cause the death, or also known as murder, a born person, he could get 5 years up to life, even capital punishment, if the jury so decided to give him that, if convicted. But if he killed intentionally caused the death or murdered a fetus, the maximum penalty was 5 years for doing that. Was that equal protection? Was the fetus equally protected even before Roe versus Wade in Texas, the same as born people? No, there was different laws to protect each differently, not equally. Or at the time, a woman or a pregnant woman, it was a crime for her, it was a homicide for her to intentionally cause the death of born people. But not only was it it wasn't just a lesser penalty, there was no penalty. She was completely immune. She could not be prosecuted at all for killing her child before birth. But if she does the same thing after birth, she could be prosecuted for murder. Was that equal protection? Because again, I said, do you think that the same laws that apply to protect me and you should apply to protect someone before they're born? And if you said yes, well, then the same law, then no one should have a license to kill, because no one has a license to kill you. No one has a license to murder you with impunity. Why do we then allow mother to do that? And I am actually not the first one to say this. In fact, you know who else also said this? The United States Supreme Court in Roe versus Wade. In the majority opinion, the court said this. The court said, when Texas urges that a fetus is entitled to 14th Amendment protection as a person, it faces a dilemma. Texas faces a dilemma because our laws, again, didn't treat the murder of a born person equally with the murder of someone not yet born. But yet we went to court and we said, justices, honorable court, may it please the court. Fetuses are persons. Fetuses are persons. And both in oral arguments and in the majority opinion, the justices said, really? You say that. But you face a dilemma. And the court went on, quote, in Texas, the woman is not a principal or an accomplice with respect to an abortion upon her. Then they said, if the fetus is a person, why is the woman not a principal or an accomplice? And they went on, the penalty for criminal abortion is significantly less than the maximum penalty for murder. The court goes on, if the fetus is a person, may the penalties be different? You see, the court was just pointing out that we were not being consistent. That we had one set of laws for born people, but a totally different set of laws for people not yet born, who we claimed were persons, but we did not treat them like all other persons. The penalty was much lower for killing fetuses than for killing born persons. And mothers were completely exempted and excluded and immune from prosecution for murdering or from being involved in killing a fetus. But she did the same thing to her born child, then she was subject to the justice system. Or if she did the same thing to her husband, if she hired someone to kill her husband, she was subject to the justice system. Well, but not when it came to fetuses. And so the Supreme Court essentially said, actions speak louder than words. And because your existing laws, Texas, and in fact, every state in the country, do not treat fetuses like they're persons, then we're not going to treat fetuses like they're persons either. And we didn't learn our lesson. We didn't learn our lesson in 1973. And pretty much every single pro-life bill since 1973 has continued this inconsistency and has continued to deny equal protection, which has continued to deny the personhood or humanity of the unborn children. So why should we expect any different result from the Supreme Court when we haven't changed our inconsistency when it comes to how we treat people before they're born? See, this is what equal protection looks like. Equal protection says everyone is prohibited from intentionally causing the death of a preborn child. Everyone. The abortionist, the father, the grandfather, the boyfriend, everyone, the mother, everyone is prohibited from intentionally causing the death, from murdering that child in the womb. That's what equal protection looks like. That's what it looks like. No one has a license to kill that child. And if someone does, then that person is subject to the same justice system that protects all of us born people, right? Whether someone kills someone born or not yet born, they should be subject to the same justice system. Now, are we saying that every case should get the exact same outcome? That the abortionist should get the exact same sentence as a mother? Of course, we're not saying that. What we're saying is that the same justice system should consider each case on a case-by-case basis, whether the victim is born or unborn. The same justice system should equally protect both. That's what we're saying. And the same justice system that has multiple juries and grand juries and appellate courts, prosecutors and law enforcement, and even the governor who can pardon or commute sentences and lower sentences, that same justice system that applies to protect you and me as born people, that same justice system should protect people not yet born. And that same justice system should also protect mothers who really are victims, right? Mothers who are forced to get an abortion under duress. Yeah, they should not be prosecuted, and our laws would not prosecute them. Mothers involved in medical emergencies would not be prosecuted either, because we already have laws. We have a necessity statute. Or mothers who don't really know what they're doing, again, should not be convicted. And they would not be, because those laws already exist. They're called duress and necessity and mistake of fact. And they're defenses to prosecution and to conviction, so that those mothers or that those alleged perpetrators will not be convicted when they are truly victims. So no one is saying that they should be. What we're saying is that every case should be considered on a case-by-case basis, just like for the homicide of a born person like you and me. And ultimately, that no one should have a license to kill a preborn human being. No one should have a license, that is government permission, to do something without any legal consequences, which is currently what we give to mothers, and what in almost every single pro-life bill is not just implicit, but is explicitly stated. This does not apply to the mother of the unborn child. We're explicitly giving them a license to kill their own preborn child. And yeah, we may take away the assistants, we may take away the abortionists and may prohibit them, but then all we're doing is, well, then what's the only legal option left? Oh, a do-it-yourself abortion? A coat hanger abortion? A mix-your-own concoction abortion? Is that really what we want to do? No, abortion should be illegal for everyone. Abortion should be illegal for everyone. So how do we ignore Roe? We enforce our existing law from before Roe versus Wade, but that law falls short of equal protection. That's why we also need a new law. We also need a new law. We need to do both, 1 and 2. Enforce the pre-Roe law. While we're doing that, work to pass a law that does provide equal protection. And we actually don't even have to create a new law, because we already have laws that protect born people, right? All we have to do is take away the abortion exception. Just take the exception for abortion away, which in Texas, in the Texas Penal Code section 19.06, take the abortion exception away. Because in Texas, preborn children are already defined as persons. So we actually have a specific exception to homicide that allows for abortion. Take that exception away, and then the same laws that protect me and you would equally protect people before they're born. And if we say that a fetus is a person, that's consistency. That's what consistency would look like. And we have a bill in Texas, and we've had one for now, this is our third session. In 2017, we had HB 948, 2019, HB 896, and now this session, House Bill 3326, that would do this, that would provide equal protection and would ignore Roe to abolish abortion this year. It's the only bill that would end abortion in Texas this year. And so we ask people to support that. But there's lots of other legislation out there that maybe you heard about, like a trigger bill or a Texas constitutional amendment or a heartbeat bill or PRENDA, the Prenatal Non-Discrimination Act, or something else that's called deceptively to the Texas Abolition Strategy. Well, a trigger bill just surrenders to Roe versus Wade because it just says once the Supreme Court gives us permission, then abortion is illegal in Texas, which we don't need because, again, that law is already on the books. The constitutional amendment just raises the standard and makes it actually even harder to end abortion in the state. So it has lots of problems. The heartbeat bill, which is one of the more popular ones right now, has already been struck down in 11 states. And Texas has a slightly different spin on it, but I think it's inevitable that it's just going to be struck down as well. The heartbeat bill just says, once the abortionist detects a heartbeat, then the abortionist may not perform an abortion. Well, that does a few things. First of all, it's kind of odd that the person who's going to be tasked or who's been paid and asked to kill this child is also the one who would be trying to detect a heartbeat. It's like, I don't hear anything. I don't hear a heartbeat. But more than that, the bill denies equal protection because it doesn't apply to mothers. Plus, it does not protect people who don't yet have a heartbeat. It discriminates against them. It dehumanizes you if you don't yet have a heartbeat. It's a false teaching about when life begins. Just like there right now, because a few years ago we passed the pain-capable, abortion ban in Texas. Now there's women walking to an abortion clinic that if you're outside holding signs, they say like, it's okay, my baby's not going to feel pain. You pass the heartbeat bill, what you're going to be hearing is, it's okay, my baby doesn't have a heartbeat. Well, that's, at some point, every baby doesn't have a heartbeat, which means every baby is still subject to being killed. Or PRENDA, the Prenatal Non-Discrimination Act, which sounds great. It sounds great. Yeah, don't abort a child because of sex or race or because of disability. That sounds great. What that's going to do from a legal perspective is the abortion clinics are just going to put a little checkbox on their form. And it's just going to say, please check here to indicate that you're not getting an abortion for an unlawful reason. Check. You can get an abortion of a Down syndrome baby under Prenatal Non-Discrimination Act, but you can just get an abortion because it's a baby, or because it's Tuesday, or because you had a bad hair day. You can get an abortion for any other reason, or you can get an abortion for a discriminatory reason, as long as you don't say it, as long as you don't tell the abortionist that, or if you do, the abortionist say like, well, I know you told me you want to abort this child because of the race of the child, but you also want to get an abortion for a lawful reason, right? Wink, wink. Oh, yeah. Okay, great. We'll go ahead. The bill's going to do nothing to save a single life, and certainly nothing to undermine Roe. And then the Texas Abolition Strategy, which is being pushed by Texas Right to Life, and we love a lot of the people over there, but we disagree on strategy here. They're using the term abolition, I believe. In this case, it's deceptive to many people. They're doing something that would happen in stages. It would be the PRENDA, and then it would be the heartbeat, and then it would be abolition but not equal protection. Wait, so your end goal is in 4 years we have abolition but not equal protection, but you're not standing up to the Supreme Court, right? And you're not providing equal protection. Well, we already have that law on the books. That's the pre-Roe law I was talking about. That's already on the books. We could just enforce that now. Why do we need to wait even 4 years for that? And here's what I would expect. You know what? These bills, a lot of these kind of bills are looking like they may pass this session here in Texas. But based upon the history of the pro-life movement that we've already kind of gone through, here's what I expect. Here's what I expect to see if these pro-life bills are passed. First of all, those bills that actually could do much to stop abortion, like the heartbeat bill, if it really went into effect, it's never going to be enforced. It's never going to be enforced because the courts are just going to say it's unconstitutional, like they've done for 48 years for any kind of ban. And when that happens, instead of standing on our constitutional rights and duties, I believe what we're going to see is that Texas instead is just going to do what we've always done, and we're going to surrender to unconstitutional judicial supremacy, which just further reinforces it and further delays true abolition. And yet, in spite of the fact that we lose, what I expect us to see is that the pro-life organizations and the pro-life politicians, they're going to claim victory between now and then. And they're going to tell us about how they passed these bills and that we're winning. And the politicians behind these bills are going to be called pro-life heroes. And Texas pro-life ranking will go up, which I don't know that that's worth a whole lot, since even the number one state still has abortion. And they're going to be celebrating. But in spite of that, people not yet born will continue to be murdered in this state, as they have after every pro-life bill we've passed. And the laws that we do choose to enforce will just continue to protect the practice of destroying human beings who are made in the image of God. And yet, the pro-life politicians and the pro-life organizations are just going to continue asking for our support, asking for our votes, asking for our money, so they can do it all again, just like we've done for the last 48 years. So what should we do instead? Well, I've already explained it. It's time to stop complying with an unconstitutional decision. It's time to stop denying equal protection to preborn people. It's time to do what we've said for 48 years, to treat Roe as unconstitutional. We've said it's unconstitutional. We need to act like it. We've said the fetus is a person. We need to act like it. Because the pro-life legislation we've been pushing for 48 years has not acted like it. The way we've treated this issue, we've not acted like that. It's time to ignore Roe, follow the Constitution, and to provide equal protection. It's time to act on what we say we believe. It's time to be an abolitionist.
Hey guys, thank you for watching. To see more content related to abolishing abortion, please like and follow this channel. To stay informed or find out how you can support the work to abolish abortion in Texas, visit our website at abolishabortiontx.org. With your support, we will continue to create content to bring greater awareness to this modern-day genocide and work to mobilize Christians to do something about it. We appreciate your support and help in sharing this content with your community of friends and family. Thank you, and God bless.